Well, a very good day to you, ladies and gentlemen. Welcome to another episode of the Candy Talk here on Herman Manyora's YouTube channel. My name is Evans Okinyi, and it's always my pleasure to have you on board on Kenya's most comprehensive political and public governance analysis show. I'm here with my resident guest, Wakili Willis Otieno, who is also a constitutional lawyer and the deputy party leader of Sabina party, and of course a potential deputy president come 2027. Wakili, good morning.
Good morning, Okinyi.
How are you?
I'm fine, thank you. Yes.
You still have the hopes that
Deputy President designate, the people's deputy.
Deputy President designate.
The people's deputy. When the people decide, they will make their choice.
The year is 2027.
And the choice is between myself and Kithure Kindiki. Who stands for the Constitution? Who defends the right to peaceably and armed to demonstrate, and who orders or superintends over the killings, forced abductions, and disappearances of our young people. That will be what we do on the ballot on that day. If Kenyans want the person who abducts and kills them, Kindiki is there. He is in good company. If they want somebody who defends the rule of law and the Constitution, I am here. The choices are clear.
So it's you versus Kindiki. Talking about the deputy president, Professor Kithure Kindiki here, of course, he gave an address back then, of course, as he was just exiting the Ministry of Interior, for which he has been in charge for over 2 years now. But then something came out clearly here is that the police are actually denying their role in all these abductions and all the killings that we've witnessed in the recent past. But at the same time, the deputy president says here that he'll work hand in hand with the incoming cabinet secretary in charge of interior to ensure that we get answers to these abductions that are happening in the country, of course. What do you make of his statement, therefore?
That is bullshit.
Why would you say so?
This way. It's bullshit. He was the one who was in charge of that ministry when the police were out killing people. He was in charge of that ministry when our young people were being abducted and some forcefully disappeared. He was in charge of that ministry when our young women were being killed all over. He was the one in charge of that ministry when the quarry killings took place. He was in charge of that ministry when this alleged suspect escaped. Why can't he start by giving us the report? His exit report should indicate these were the abductions, these are the officers responsible, they've been charged. These are the ones who killed, these are the ones who abducted. These are the vehicles they were using, because the pictures are there. Pictures don't lie. We have videos, images of men in civilian wearing balaclavas in civilian vehicles, moving around, shooting directly. In fact, they didn't start even at this year's demonstrations. Even during the Raila Odinga demonstrations of last year, you saw policemen firing canisters right into Raila Odinga's media vehicle. The images are there. Using AI, you can track down the person who is behind the canister. You can tell the officer. You can tell who deployed, which unit deployed or deployed in that area. Who was the officer in charge. All those canisters, all those bullets, the cartridges, you can trace using the number which of police station they were delivered to and which officer was issued with that particular canister or cartridge. And you can tell. Why has not done that? So, what is he going to do as deputy president that he couldn't do as CS Interior? He was standing in front of Arambe House, threatening Kenyans with a soprano voice of dire consequences if they peaceably and unarmed demonstrate. He was actually attacking our constitution and diminishing the rights to peaceably and armed to demonstrate, Article 37. So, there's nothing new Kindiki is telling us. That is gaslighting. That's why I call it bullshit. There's nothing that will come out of that man. That man is William Ruto's poodle. He is a poodle serving at the behest of his master. And if it means to kill Kenyans, to abduct, to forcibly disappear Kenyans, will please his master, he will turn a blind eye when it's happening. Like he has turned a blind eye to the killings, the abductions, and the forced disappearances. Not even a single officer today has been investigated and charged for those offenses. And yet, there's enough material to point out which charge the officers who committed some of these offences. We have enough of that in the internet.
Okay.
Kenyans took photos, and photos don't lie. There are videos of these police officers, or even if they are not police officers. Why is it arresting them? Why didn't they have them arrested, arraigned in court, and charged? And who are these civilians who can be walking around in an unmarked vehicle, wearing civilians, and they walk in between police officers and nothing is done to them? Are we a rogue republic? No. That is what we call the legacy of Kithure Kindiki in the ministry as well CS Interior. That is his legacy. He cannot run away from it. Kithure Kindiki taught me in university. He taught me law, and constitutional law in particular, and criminal procedure. What he has practiced in office is not what we learned in school. Because the sanctity of human life, the sanctity of our Bill of Rights cannot be gainsaid. And you cannot sit in an executive position and superintend over gross violations of human rights, including killings.
At a time of crisis, as we witnessed back then, holding such a critical docket for him, what do you think Kithure Kindiki would have done perhaps differently? Or if at all you are in that position as the man in charge of the country's security and all that was happening in the country, what then could you have done differently in order to prevent all this now that we are not
It is
witnessing?
purely a case of apply the Constitution. What does the Constitution say? Article 37 gives Kenya the right to demonstrate. And once Kenyans go out to demonstrate, you may not like the message, but you give them, you don't interfere with their right to pass that message. You don't incite goons to go and attack the demonstrators. You don't deploy militias to go and attack the demonstrators. You don't engage in acts of shooting live bullets at demonstrators. So what I could have done differently, I would have applied the Constitution, which he did not.
Okay.
And for me and my people, the Constitution is our north. That is what we refer to. If the people have decided to exercise their rights in the Constitution, it is not within the rights of anybody in executive to undermine that Constitution. What he was doing was to undermine the Constitution because he didn't like the message. If we had similar demonstrations of people demonstrating in support of William Ruto himself, you will be happy to facilitate them.
Okay.
Why is that when the message is against him? They engage in killings, abductions, for disappearances. No. That is the difference between me and Kindiki. I respect the Constitution. The Constitution is my constant north. And the rights therein are not rights to please me, are rights which Kenyans have negotiated and put in their Constitution. As a duty bearer, your duty is purely to facilitate the enjoyment of those rights, not to inhibit. He inhibited the enjoyment of those rights. That is the difference between myself and him.
Okay. Now, and let's take it here because right now, currently, he is the deputy president, and of course, as the principal assistant to the president, he's also mandated to ensure that everything runs smoothly in this country and that Kenyans' lives are protected. But then, recently, we've witnessed this kind of, let me say, sort of representation of some confusion between how then these arms of government should actually function. The deputy president here is now the member of the executive, and of course we have the judiciary and we also have the National Assembly. But then going by the recent rulings, of course, certain rulings by the courts that gave an okay to some of the policies of the government. Of course, you remember what the courts recently talked about, the Finance Act 2023, and of course, the housing levy. And recently, we also witnessed a situation whereby the president was actually asking, well, the courts are here to intervene whenever there are excesses, but then who actually checks the courts as well? So I want us to have this conversation. There are certain people who actually feel in this country that somehow our judiciary is captured and kind of compromised, going by these recent rulings.
I will not say the judiciary is captured, but I will say the Supreme Court is captured. Because within the judiciary, we have within the rank and file, magistrates, high court judges, court of appeal judges, employment and labor relations court judges, environment and land court judges, and tribunals, which are toiling and applying the Constitution and our laws as we know it, painstakingly, spending long hours to apply that Constitution. But then you have a Supreme Court that is turning out to be an oxymoron. You cannot tell its front and its back. It comes out with a decision today, you go and advise your clients, this is what the law says as per the Supreme Court. The next day you go to court on that same issue, the same Supreme Court decides opposite. The Supreme Court is the weakest link in our judicial system today. That is something that any Kenyan who practices law in this country, or anybody who is keen to observe issues of governance, will tell you. The Supreme Court is the weakest link. You saw them even holding their seminar last week. What were they talking about? They just called the executive to rub their backs. The Supreme Court is our weakest link. You cannot even tell what is their jurisprudential value to this nation. Nowadays, this Supreme Court, he has even cases of inheritance. People fighting over a dead man's property. You find the Supreme Court, because the amount involved is colossal, they are assuming jurisdiction. And they litigate, they hear it. What is that? These are matters which were meant to end at the High Court, at the Court of Appeal. Look at the governor petitions. The Constitution gave the Supreme Court jurisdiction only on presidential election petitions. Nowadays, all governors' petitions end up at the Supreme Court. And there's only one outcome from those cases. There is not a single governor petition which the High Court has allowed, or the Court of Appeal has allowed, that has gone to the Supreme Court, and the Supreme Court has allowed. They have always sided with the sitting governors 100%. In all the gubernatorial petitions that have gone before the Supreme Court, they have decided for the governors sitting 100%. Not even 99. Why? Are you telling me the High Court that dealt with the matter at first instance, took all the evidence, was wrong? Court of Appeal that, for example, uphold that decision was wrong? That now it is them who didn't have the opportunity to meet the witnesses, to analyze the evidence that was presented, that all of a sudden they know. I mean, there's a perception here.
So for you here, what is actually wrong? Is it them listening to the case or the outcome?
To begin with, they should not have the opportunity to listen to that case. To begin with. To begin with, the Supreme Court has no business listening to governor or MP petitions. Their jurisdiction in the Constitution was only limited to presidential election petitions. But they found an ingenious way that it involves application of the Constitution, now bring them to us. All of a sudden, it has become a new Court of Appeal.
Are they really limited to
hearing at the Constitution? It is very clear. Their jurisdiction on petition is presidential election petitions. They have decided to apply an article 163.4 that gave them the jurisdiction to deal with any matter that involves interpretation or application of the Constitution. It was never envisaged that it will be on petitions. It was never. In our Constitution and our laws, we had hoped that election petitions will be resolved within 1 year. 6 months High Court, 6 months Court of Appeal. Nowadays, they can sit on petitions even 2 years at the Supreme Court. Why? They don't even respect the timelines which we gave ourselves, that election petitions should be concluded within 1 year. They can sit on a petition even for another 1 year. Yet they have no jurisdiction. But the perception that comes out is that because the sitting governors have resources, and we are not sure if they are also being massaged with those resources. That is why 100% petitions before Supreme Court on gubernatorial have been decided 100% in favor of sitting governors.
Talk to me about your tweet in response, or rather your post on X in response to what Ahmed Nasir actually posted on the saying very well that there are people here. Of course, he mentioned a number of people without actually specifying a certain individual, talking about judges, the Supreme Court, and all such manner of people whom he believes that are somehow compromised.
It's highly possible and probable that there may be judges in the Supreme Court who are compromised. One thing that I must mention is this. Look at the decision of the Supreme Court of Kenya. There are 7 judges. 99% of the cases they hear, they reach a unanimous decision. 99%. Where is the individual thinking? What is this collegiate unanimity that you don't even find dissenting opinion? In a functioning judiciary, you will expect the 7 judges to each have their own opinion. We want to understand their legal philosophy, their thinking in their writing. They should all write their own judgments. Then we go by the majority. But to them, one judgment is written. The rest, just sign. Who writes it? We don't even know. So why do we maintain 7 judges? When all we get always just one judgment. Because the beauty of dissent, when you have different judges writing, everybody brings their minds into a judgment. And you can even use a dissenting judge's opinion as a persuasive argument. You understand his legal philosophy, what his thinking is. To them, one judgment. Then maybe we should just have one Supreme Court judge. Because all they give us is one judgment anyway. We never see 7 judges dissecting an issue, even if they all arrive at the same conclusion. We want to see their legal thinking, how they've dissected it. Because they cannot, as the 7 of them, have only one mind that writes only one judgment and they all sign. Doesn't make sense. I mean, let's be serious here. We are getting a raw deal from the Supreme Court of Kenya. When it came to the public participation, the finance bill.
And that is where I wanted to get to.
They mentioned the public participation that was done. Who said it was not done? The argument is very simple. Public participation must be qualitative and quantitative. Qualitative to mean when the people go out to participate, they give you their views. You incorporate their views in your decision. And if you don't agree with their views, you give reasons. So if 99% of Kenyans who gave their views on the finance bill rejected it, I mean, it must mean something. Because what they've ended up doing is they're trying to reduce public participation to be a conveyor belt, just ticking a box that we went to the people. But what did the people say? And how did you inculcate the people's views in your decision? You must give reasons. That has been the jurisprudence from the courts. To them now they're saying, blank check. It was done. But the quality, they don't care. They say the Appropriations Act 2023 had both the estimates of revenue and expenditure. In fact, they say you don't even need to have it. But the Constitution in 220 says you must have a budget, and a budget must have both revenue estimates and expenditure estimates.
Definitely.
Those two are what constitutes a budget. These characters pass an Appropriations Act that only has expenditure, no revenue side of it. So what are you going to spend if you don't give us the revenue? And the Supreme Court says that's okay. How? And the reason why they are not putting the revenue is important Kenyans to understand, because if you put the revenue, estimated revenue, and the sources, we will tie you. You will say, I'll take loans of this much. And on expenditure side, you will write, this loan will be applied towards this road.
Okay.
So that when government goes to borrow money, we will know this money that's being borrowed will be for this particular project. So Supreme Court tells them, they don't need to do that. They just need to tell us how they are going to expend. Where they'll get the money is not our business. That is why we have a runaway debt problem in this country. Okay. Debt is a problem because the executive refuses to disclose which loans they are taking and which project they are funding and where's the parliamentary approval. Okay. You saw William Ruto casually say, after reject finance bill, I'm now going to borrow 1 trillion shillings. Who gave him the authority? To use it, to apply it to what project? Because in our laws, debt, you only take debt for project finance, development. So when he says, I'm going to borrow 1 trillion, which roads is he going to build? Which airport? Which dam? Nothing. So he's going to borrow 1 trillion in your name as a Kenyan, and how he's going to use it, you don't know. That is why, as a Sabina, we say the bulk of our debt is illegal. Okay. It is odious debt. So they go to the domestic market here to borrow money. Bills and bonds every so often. Tell me, those treasury bills and bonds, those are debts. Which project are they funding? Nobody can show you. Okay. And why that is important is important Kenyans understand this. The money that the banks lend you, the Kenya government, is your deposit. It is your money that you've taken to the bank. It is government's money, because most government ministries and departments, in fact, all of them, they keep their money in banks. So it's government's money and the people's money. Then the bank, as the recipient of the money, goes to the government and lends the same money to the government at high interest rate, 17%. Then government comes to you, the owner of the money, to increase your taxes, to pay this bank interest rate for lending your own money. That's nonsense. And that is what we had hoped the Supreme Court ought to cure. The Court of Appeal, in expressing itself, said that a budget must have revenue estimates and expenditure estimates. So we'll be able to tell, even the issue of borrowing, you can follow it through. We cannot support Supreme Court. They are useless.
So, Wakili, what do you think is happening here? Because we are having a situation whereby we're supposed to be applying here the same law, and its interpretation should be more or less similar when it comes to now those whom we've given the mandate to interpret the law for us, that is the judiciary. And here you're saying that the appellate court was actually right in its ruling therein. So why do you think there is that kind of inconsistency in all this? What could be happening? Could there be some sort of power beyond the law of this?
That is what I say. Then I now seek solace in what Ahmed is saying. Because if I look at the legal reasoning and our laws, I will expect them to arrive at the same decision like the High Court, Court of Appeal. Because they also read the same constitution. But it appears there's a special constitution in the Supreme Court, which they are reading. We don't have a copy of that constitution. Maybe, as Ahmed says, it is jure pesa. I don't know. Maybe it is jure pesa. But there seems to be something up there that the rest of us don't know. Either they have their own constitution or they have jure pesa. We don't know what it is. But what we know, which is factual, is that whatever decision they are coming up with, compared to what other courts are coming up with, are different. So they're not reading the same constitution.
The Chief Justice spoke and said that she cannot be influenced, and nobody has ever tried to influence her anyway, in as much as that is the perception on the ground based on their recent rulings, especially with the Finance Act 2023.
You know, the less said about Madam Hotea, the better. Because let the facts speak for themselves. Res ipsa locita. Yeah. You know, they say that a leopard, a toad, does not jump during the day for no reason. Who asked her if she has been compromised? Why does she feel the need to defend herself? Yeah, who asked her? If you see a toad jumping, there must be a reason. Why is she quick to jump? Okay. Nobody has asked her if she's been compromised. So the less said, the better.
So the judiciary here, the executive arm of the government, and then finally the National Assembly. And we are having all these things here, and certain people actually have lost hope now in the judiciary as well. What would be the last, let me say, hope, or rather form?
The last hope is the people of Kenya. And the thunder that is coming to strike these three arms, and I'll say Supreme Court, executive and legislature, that thunder is still doing press-ups. It is going to hit them hard when times for elections come. They will not believe it. Just like the American system had been captured by the woke society. You saw what happened with Trump. You know that Trump is a great man, but people are rejecting an organized system. And you saw it in the elections. So also in Kenya, the thunder that will strike these three entities, still doing press-ups, it's coming. That day when the people will go out to vote, you will see a turnout that you've never seen in the history of this nation. And you will see a country that is united on one core issue, the economy and good governance.
Therefore, you say that we need a total overhaul of the system. Okay, ladies and gentlemen, that is it from Wakili Willis Otieno here. Kindly weigh in and tell us what you think about what is actually going on in this country with regards to the recent rulings by the Supreme Court, especially on the Finance Act 2023 and, of course, they gave the government the nod to go ahead and continue implementing that same policy, which had been declared null and void and of course illegal by the appellate court, but the government decided to appeal at the Supreme Court. Well, tell us what you think about all these developments in the country, but stay tuned to some of our programs that will be coming up next year. Jadel Kabiro is always here with these political conversations as well. Ladies and gentlemen, allow me to stop for now till we have this conversation again. My name is Evans Okinyi.